Let's get reaction to the story now. We're joined by attorney at the Women's Legal Centre, Bronwyn Petey, from our Cape Town studio. Thanks for your time, Bronwyn. Appreciate it. What's your initial reaction to this ruling being upheld by the Constitutional Court?
No, look, we're very supportive of the ruling. We're very happy that the Constitutional Court has found in favour of the applicant, and we as Women's Legal Centre were respondents in the matter, so we also participated. And I think it's a real reflection on the court understanding the lives of victims of sexual offences, be they children or adults, and understanding that there really is no distinction that can be made between types of sexual offences such as rape or sexual assault or indecent assault.
This, of course, sets the way for anyone who experienced sexual assault many, many years ago to now come up and say, we want to challenge this in court.
Exactly. You know, the previous section, as you mentioned, drew a distinction between rape and other sexual offences. So rape is never prescribed. There's never been a so-called statute of limitations on rape. But for all other sexual offences, you had 20 years in which to report it. Otherwise, it couldn't be prosecuted. So what this now does is that it recognises that there are many reasons why women and children, men as well, obviously, don't come forward immediately and report any abuse that has happened to them. And it really failed to recognise that the type of trauma that is experienced by victims, whether it's a rape or any other type of sexual offence, is similar. You cannot distinguish between the two, and that's what the court found. It said it was an arbitrary distinction, and like you say, it opens the door for people who were abused many, many years ago, whether it's 50 years ago, 60, 70 years ago, can now come forward, report to the police, and there is a chance that the prosecution, obviously depending on the amount of available evidence, may very well decide to proceed with the prosecution.
Well, that's what I want to talk about, the evidence. Some people would argue that when a rape occurs even, it's hard to prove it in court due to a lack of evidence, due to the fact that people don't go to hospitals soon enough or clinics. How then do you actually challenge something that happened 40 years ago?
Well, look, you know, at the moment, many rapes are reported and there isn't any so-called hard evidence in the sense that there are physical injuries, the evidence or availability, as it were, of other types of evidence. So, you know, the same argument could be made for something that happened many years ago. There are many other types of evidence that one can rely on. The very statement of the complainant obviously holds water. These cases will be tested in court, and it's up to the courts to weigh the evidence that is presented. You know, very often in child abuse cases in particular, there is very little evidence because children take a very long time to report. So by the time they actually do so, there's very little medical evidence. And the courts have found that to rely only on medical evidence is simply not required. There are a lot of other aspects of things, especially with explanations as to why people don't report immediately. So I don't think that's a valid concern. I think the very fact that people can come forward, make statements, and it can be investigated really indicates a proper right to access justice. And that's really what the case is about. It's about improving access to justice.
All right, Bronwyn, thanks for your time and your insight. Really do appreciate it.